Good morning, Your Honors. The matter before the court is the case entitled In Re Appeal of K.P., case number 24 AP 357. Representing the appellant, K.P., is George E. Gay. Representing the appellee, State of Vermont, is Edward Kenny.
Okay, thanks very much. And good morning, counsel. We'll hear from counsel for the appellant first, of course. Please, for the record, introduce yourself and identify your client and then proceed.
Good morning, Your Honors. My name is George Gay. My client's name is Ms. Carrie Plant.
Thank you.
And may it please the court, we are here this morning to determine whether the board has jurisdiction to hear petitioner appellant's appeal. The court has determined with respect to the issue of jurisdiction and appeals that they are entitled to liberal and objective construction to further rather than restrict the right of review. That determination was in State v. Brown, 121 Vermont, and it was followed in Casella Construction versus Department of Taxes in 2005. That's the issue, that's the context. A reviewer's decision provided to Ms. Plant, the petitioner appellant, that she may appeal the DCF decision by writing to it within 30 days of when the reviewer's letter was date stamped by the post office. That language came to Ms. Plant in a letter on April 20th. She received it. The appeal language is by writing to the board within 30 days of when the letter is date stamped by the post office. We wrote to the board on May 14th, 27 days after April 17th. That letter, according to DCF, was received on May 20th. We believe that in writing to the board on May 14th, we perfected our appeal rights because we wrote 27 days after the letter that DCF sent us with the reviewer's decision. Your Honors, date stamped by the PO is a procedural requirement of the board. They conveyed that requirement to my client. Champlain Parkway, a decision of this court, says agencies are to follow their procedural requirements unless they meet the 4 factors for an exception that are set out in the American farmland case. In this case, the date stamped by the PO requirement was to protect my client, the appellant's rights, so that she knew exactly when her appeal period began, when the letter was date stamped by the post office. DCF didn't follow that procedural requirement, and as a result, what should the date be that the appeal period begins? Should it be the date of the letter, April 17th, even though the letter wasn't date stamped like it was supposed to be, according to the DCF rules? Or should it be when my client received it? That was April 20th. If we follow the Champlain Parkway requirement, if we apply that to this case, then the 30 days runs on May 20th, which is when DCF claims it received the appeal. So we comply again. There is a fail-safe, Your Honor, in this instance, which is good.
You have 1 minute. You have 1 minute.
Thank you very much, Your Honor. When there is a late filing, the Human Resources Board can waive the 30-day requirement for good cause. Here, my client put it in the mail 27 days after the date of the letter. It took 4 days for the mail to deliver the appeal to the Human Resources Board. 4 business days. In the case of grievance of Mason, I know it's not controlling, Your Honor, but the Vermont Labor Relations Board had almost the same facts. A party put an appeal in the mail, and it took 6 days for it to get to its destination. The Labor Relations Board looked at Vermont Rule of Civil Procedure 6E and determined that it was reasonable for an appellant to believe that it would only take 3 days for a letter to be delivered in Vermont. And in that case, and this is quoting from that decision from the Vermont Labor Relations Board, although the board had not formally adopted Rule 6E, the Labor Relations Board, a sister agency, said, we believe it sets forth a reasonable presumption upon which a person can rely.
Okay.
Thank you, Your Honor.
Thank you. Your time has expired. We'll hear now from counsel for the appellee. Please, for the record, introduce yourself, identify your client, and then proceed.
Thank you, Your Honors. My name is Edward Kenny. I'm an Assistant Attorney General representing the State of Vermont Department for Children and Families, DCF. Your Honor, I would make just a very brief number of points. First of all, meeting a filing deadline for an appellate tribunal is jurisdictional, particularly it's specifically said in numerous cases before this court for the Human Services Board. That deadline is 30 days. This court has interpreted that statute and the administrative rule that governs these things to mean that it has to be received by the appellate entity within 30 days, not mailed. There's no, I couldn't find any cases where that was different. I would point out that I don't think the Rule 6E and the Civil Rules of Civil Procedure exists anymore. I think the modifications to the rule have done away with that. But there are just a tremendous number of cases where this court interprets perfecting an appeal under statutory language requiring that it has to be delivered, it has to be received by within 30 days.
Mr. Kenny,
yes.
Attorney Kenny, do any of those cases have facts similar to this where there was no date stamp and the person who might be choosing to appeal doesn't know when the appeal is supposed to be filed by?
I don't believe that they do, but relative to the date stamp issue, Your Honor, that's an interesting question. Frankly, the idea that a letter is date stamped by the U.S. Postal Service and not the envelope is something that's a new concept, at least to me. Envelopes are postmarked, and I think that's what the interpretation should be here. The idea that you would bring a letter to the Postal Service and say, would you date stamp this, please? Now I'm going to put it in the envelope, put a stamp on it, and hand it back to you for mailing. I don't think there's even a procedure in the post office for such a thing. The letter itself was stamped, and the Human Services Board found as a factual matter that it was mailed on the date upon which it was stamped.
But
I'm sorry, not stamped.
That was after the fact, though. I mean, that's when it got to hearing. I mean, she didn't have that information available to her when she was trying to decide when she had to mail by.
Well, I guess my response to that, Your Honor, would be that the plaintiff appellant in this situation would be the one who would know when it was put in the mail, because when the envelope was put in the mail, because they had the envelope and they didn't produce it as part of their argument for a good cause. And that envelope very likely, according to the Human Services Board, would have had, I don't think they actually found this as a fact, but I think it's implied that the postage, the date on the outside of the envelope would have been the same as the date that the letter had, which would have been the start of the 30 days.
Would that be on April 17th then, Mr. Kenny?
I believe so.
Okay. And that is a finding of fact by the board, by the review board?
Yes, when, under the auspices of the good cause question, the board found that the date on the letter was the date it was mailed.
Thank
They
you.
also specifically said that the appellant is in the best position to prove the date stamp, what the date stamp says.
You have 1 minute, counsel. 1 minute.
Thank you, Your Honor. She's the one that received the letter. Relative to the Labor Relations Board case, that is not, I wouldn't say that's persuasive, to say nothing of whether it's controlling, because it's from 1992. There's no indication that the decision was subject to argument by attorneys. And after that, this court has ruled any number of times that an appeal to be perfected has to be received within the statutory period here, 30 days. That serves a significant purpose of finality, that parties to a case have a expectation that they will know when the case is over. If somebody doesn't perfect an appeal, the case is over. So there are substantive reasons, not just technical reasons, why this is something that should be upheld. Thank you.
Okay, your time has expired. Does the appellant have any time?
Appellant has no time remaining.
All right, please call the conclusion of the hearing.
The next hearing for the court is scheduled for 9:45 this morning.